McEvoy, Clay County Collector. I just wanted to take a moment today to renew my request for opting out of the transparency portal. I checked it this morning and my employees are still there. And I requested that last week, and I believe that there's a continuing negative impact on my one employee in particular. You did ask me last week to complete a thorough investigation of that allegation, and I did so, and I submitted a written record of that investigation to HR and County Council on Thursday of last week. The result of my investigation indicates that the only request from the complaining party is to have her information removed from the portal. She believes this is the best way the county can alleviate the current harassment and prevent further bullying by the perpetrator. And at this time, she has chosen to keep her complaint anonymous. The commission noted last week that it is a good thing for people in the public to be able to remain anonymous when they are exercising their rights. And so I just ask that my employees' privacy also be respected, just as much as we are respecting the privacy of the members of the public who are trying to access the portal or to access public information. In summary, I was told I could opt out of the portal, and I'm asking to opt out. I feel at this point that I'm being made complicit in the ongoing harassment of my employee because my request to opt out has not yet resulted in action. I know that there's labor an issue, that it's a technical issue, possibly. So with all due respect, I simply ask that you please get the information of my employees off the portal, and it would be awesome if that could be by the close of business today.
Have you filled out a form to that effect?
I submitted the request to County Council.
Form that we asked for opting out. Have you submitted?
I submitted a written letter to you guys last week, and I asked for a form, and I have not been given any form. I don't have a form.
The form's been available for about 3 weeks now.
Where do I access the form?
Your staff, I'm sure that, I'm sure you need on that. As I said last week, if you could get with Dean, he will provide you with the form. I don't know.
My request was in writing last week, and there was an allegation of harassment and bullying.
We need to have, obviously we need to be procedural here.
I will fill out the form right now.
So, get with staff and see if we can get the form that we've set the process up from day one, and we don't, we understand people may want to opt out, but.
I can fill out a form. No one mentioned a form last week. I was asked to do the harassment investigation on my employee last week. Seemed to be the focus of the conversation, so I did that. I will do whatever steps are necessary. So how do I get a copy of that form? Because I'd like to do it right away if possible.
Commissioner Richmond?
The county administrator, I believe you published deadlines for opting out of the transparency portal.
Yeah, there were emails.
More than one.
Yes.
There has to be some mechanism for future office holders to be able to opt out as well. Otherwise, it's treated. There was no thing of forever confused.
Hold on just a second. Was there a deadline that was stated in there?
I believe so.
Okay.
There was no deadline for opting out. I respectfully disagree. There was an indication that we wanted a meeting to look at it, that we needed to do that. I didn't need to look at it because I don't mind public information being out there, generally speaking. Whatever format you choose to put it is fine.
You can address it to me.
Okay.
Not the letter, which you can address me. The other thing is, you've read our employment manual.
Yes.
In our employment manual, it says that the information is public.
Yes, it is public.
So as a condition of her employment, all that information is public. And you don't want the taxpayers to not have access to the information having to do lawfully with the employees in your office.
Here's the deal. As of last week when I made this request, I put all the information by position
That was
on
what I
there.
asked you.
I would like the same respect that another office holder was given who opted out. We are given the opportunity to opt out.
She opted out timely. I have a question for our HR director. What is your standard policy when an allegation of any kind of complaint, discrimination, harassment, bullying, anything of that nature for any employee, what is your standard operating policy that is followed pursuant to our employment manual?
This is Laurie Portwood, Assistant County Administrator over Finance and Administrative Services. It would be Human Resources would conduct an investigation by having a meeting with the person and anyone else that may be a witness to the allegation.
Have you been given access to 2 employees which the collector refers to?
No.
Have you asked? Okay, so you've asked asked for
I'm
access.
sorry, could you, the microphones, could you repeat that just to make sure it's accurate? They're doing the transfer of microphones.
When HR has been made aware of a situation where any investigation needs to be conducted, Human Resources does the investigation, their own investigation of the employees as well as any witnesses. It takes witness statements as well. That information then is also reviewed with legal counsel. I have asked, I think once, maybe twice, for the names of those employees that were stating that they've been harassed due to the transparency portal, and I have not received those names.
As I'm sure the HR Director and County Council know, complaining employees must be given the opportunity to complain to the party that they feel comfortable. We cannot have only one path for a complaint. That is actually a known fact with discrimination, and they are not comfortable.
The employment manual says that they need to go through HR and all that's kept private. The other thing is you made certain allegations about employees that you have not revealed to HR, you have not revealed to legal counsel, you have not revealed the details, you have continued to say that there's harassment and bullying. You have not revealed any of that information.
I haven't revealed all the information that they gave me.
And you said that you personally conducted the investigation. How in the world can an employee counter anything that their own employee said, their own employer says happened? We cannot rely on the reliability of what they report to you, because if they say anything different than what you said, they could get fired. I mean, don't you understand the intimidation that's involved with that?
I do. That's why I am the party that they have chosen. They cannot be intimidated and forced to report to a party that they are not comfortable reporting. I don't know why they're not comfortable. Lori, I know, would respect their privacy. I understand that. She would do a great job. But employees must be given the opportunity to report to whom they are comfortable.
So they feel comfortable reporting to their employer that holds the sword over their salary, whether or not you are right in claiming the harassment and bullying.
That's the question.
Well, the question is, how can they possibly say everything they want to say that might possibly contradict what you've already said when you hold the sword over their salary,
This has nothing to do with their salary.
their job?
They know that I can opt out, and that's what they asked me to do. When they spoke to me about it, I said I was given an option to opt out. Would that make you feel comfortable? Is that? And they said absolutely. That is what they're requesting. Actually, they started with, can I get my name off? And then I said yes, because I can opt out.
Legal counsel?
Yes.
Commissioner Graham, you've also reached out to Collector McEvoy and tried to obtain the names of these particular individuals, correct?
Ms. McEvoy and I met last week and discussed this also.
You've not been given the names of the employees.
That was my understanding from the collector that the two subject employees not wish to be
Even though there would be attorney-client privilege.
Yes.
Commissioner, presiding commissioner, we have a situation here where this transparency portal is extremely important, and the effectiveness of the transparency portal is extremely important. And, you know, I hate to use a silly analogy, but it's the best analogy that I can think of. When we have people who have been given deadlines, and there are rules, and the employee manual states such, and then we have someone making allegations, and we're not allowed to follow our normal procedures, the names of the people are never disclosed even to legal counsel under attorney-client privilege, then we can't let anybody, whether it's the collector or any other office holder or any other department head, play hokey, put your foot in, put your foot out, put your foot in, put your foot out, with something as important as sunshineable information in the transparency portal. And what we do here today is going to set the model for whether or not our policies are going to be followed, our HR department is going to be respected, our legal counsel is going to be respected, and whether or not, in fact, the decision of this commission to participate in the transparency portal is going to be respected. So, having said all that,
With due respect, I need to clarify a few things. Mr. Graham would not be my employee's attorney. Therefore, there may not be attorney-client privilege. His client is the county, and he would need to act in the best interest of the county.
Excuse me for a moment. Mr. Graham, what is your view of, would you consider yourself bound by a client attorney privilege in that situation?
snack board is exactly right. The individual for the county is my client. Based on that, I would consider it challenge.
So you would consider that the employee speaking to you would be a protected conversation?
Typically, what I would do is if I were meeting with the board to discuss an application, one of the first things we do is part of what this snack board is I would explore to what extent that employee is comfortable to be sharing maybe the information with HR. For example, the first day I had this is I work with HR to let them know what the board complaints are. Generally speaking, that the office holder question in HR would typically be the two folks that I would want to be able to access if I could, and that's generally where the extent of it. But that's kind of the extent of who I would discuss. I would explain that I want to get permission from you.
Okay, but certainly you're not, you feel that there is a protection afforded that way if they have a conversation.
I think I have that duty, in addition to that, sunshine law, that is the representation of public disclosure of their personal.
Certainly these are personal matters that are protected from sunshine law. I'm a little bit confused when we're talking about HR issues and someone does have a concern. The idea that they can only who they're comfortable with. I mean, should these issues not come to HR as opposed?
Commissioner, if I could ask.
But the reason, let me explain just a little bit further, is if I'm working, under that post, if I happen to feel that my peer next to me is the only person I feel comfortable with, we really need, we can't resolve problems until we know about problems. And unless those go through HR, we really don't understand the underlying issues, and they're not able to deal. I'm not talking about this in specifics, but generally speaking, how do we address employee concerns if they don't go through HR, which is the entity set up to actually deal with those. And if you're not cooperating with HR, it's hard for us to
I'm
see how this
cooperating fully
works.
with HR. I gave them a copy of the investigation. Councilor Graham, could you please?
I'm sorry. No.
Okay, then I'll address you. I'm sorry.
Please do.
Okay. I would respectfully ask you, so that you can act in the best interest of the county, for confirmation from your legal counsel whether or not there have been situations where someone was told in an organization that they had a specific path that they had to follow for reporting something, and that did actually end up being part of the liability of the organization because there was not an alternate path and that person was not comfortable choosing the path that was given to them. That has actually happened. There are legal cases out there where someone was told you must go to your super, you must follow this path, and they were not comfortable doing so, and the organization faced further liability because they had not provided an alternate path. My employee came to me, I am their supervisor. I came to you, I came to county council, I came to HR, I completed an investigation in writing, with details, I submitted it to all of them, I met with county council. There has been awareness given to all the decision makers in this case so that you can make a good decision, so that you can decide whether or not to protect yourself from further liability. That's the point of having HR, is so that you can know as an organization and advise and act appropriately. The employee has chosen not to report directly to HR, but I have cooperated fully with everything that you have asked me. And it is her right, just like it was the right of the person that went to the portal in the first place, to remain anonymous, to exercise her rights.
It just hit me that this is not a situation without precedent in the county. We have health insurance. In fact, we're going to be discussing a little bit of that. We have a deadline for an employee to be able to opt into our health insurance policy or opt out. There's a deadline. If I'm not mistaken, is that deadline pretty solid?
Yes.
So I mean, we're not talking about, when we're talking about deadlines that are put out there, we're not talking about deadlines that are, it's
There was
unknown.
no deadline for opting out in that email.
I would want to have the emails in
Never
front of me,
expressed.
but I'm almost positive that we're because
It said, please meet with us to look at it. Nothing ever said that. And the assumption would be that future office holders, of course, would have an option to opt in or out, because nothing that one office holder does can bind another office holder. So there has to be a mechanism for removing this information in the future. So I am here asking for it to be removed. I didn't know about harassment and bullying. I didn't oppose the transparency portal. That's why I didn't opt out. I have nothing wrong with giving this information to the public. But I can't be made to be complicit in a situation that's harming an employee of mine.
I think what we need
I am
to do is
liable as
maybe
well.
make, put together a similar thing that we do with every other deadline, budgetary deadlines, which you're aware of, all the other deadlines, and that is to have it be an annual thing. So I think we are looking at making this an annual opt-out. The option is extended.
That's fine. I would ask you to be careful. If there's a specific complaint of harm, there's exigent circumstances. This is exigent circumstances. I wouldn't be here. I have no problem with the transparency portal personally. I would not be here if I didn't have a complaint from my employee asking for this. This is exigent circumstances. So regardless of what was expressed, this is a bit of an emergency. This is liability. And I'm complicit as well. Because in an office holder's department, rather than a department head and an office holder, I'm on the complaint as well if I don't act
And what would
appropriately.
be your liability if you were on it?
That we are continuing actions when she's asked us to
The thing
specifically
is,
stop.
you professionally have no liability. Those claims go to the county, not to your office.
That's not always happened historically. The office holder can, and besides, I answer directly to the people.
In any case, we discussed this through, and originally I was inclined to perhaps allow the latitude. I think given the way this discussion is done, I think we set a deadline. It was in writing. We will certainly furnish you with copies of how we got that to you, so that we can furnish copies of.
Nowhere in any, I'm just going to say publicly because the public won't get those emails. Nowhere in any of those emails said that there was a deadline to opt out. There was a time frame for when it would be put up and for us to come look at it. There was no deadline to opt out, and this complaint arose afterwards.
Mr. Administrator, was there a deadline set for it?
I believe there was, but I'm not going to say it.
I think the best
It's
thing for us to
exigent
do is
circumstances.
to, when there's obviously a difference of opinion and there is objective documentation that will resolve the issue, I think the best thing to do is to end this discussion now, go back to the original documents and to see what exactly the case was, so that if there was a written deadline that was established, we know it. If there was not, we know it. So
And regardless what the documents say.
we go back to the original documents that you're provided with.
I'm confident in the documents, but regardless what they say, I'm asking you to protect my employee. And if you refuse to do so, I don't think the deadline is all that relevant to her.
Commissioner?
Yes.
There are, I would like it to be noted that in the Sunshine Law, there are no exigent circumstances. There are no emergencies with regard to that. We've gone above and beyond by allowing some sort of an opt-out, even above and beyond the Sunshine Law. But to my knowledge, and counsel can correct me if I'm wrong, the Missouri Sunshine Law says this information is available, period.
And she's not asking to be
That's correct.
exempt from the Sunshine Law, she's asking to be removed from the portal. The state of Missouri does have an opt-out procedure.
And the other thing that I would also ask the collector, this is a matter that can be brought to legal counsel. This is a matter that can be brought to the county administrator. And that is how I would ask for it to be handled in the future, because as Commissioner Nolte, presiding commissioner, aptly pointed out, every time you come here in public, you are making a record for which you and your office will bear no legal liability whatsoever. It will only be the taxpayers of Clay County and this commission. This is a matter that can be handled through council and through the county administrator, and does not have to be handled here.
But I need your permission to opt out. I've gone to them. You're answering me. No, I need your permission to opt out.
You have to comply with the rules.
Okay, I'll fill out that form. So if I fill
Well,
out
no,
the
the
form,
thing is-
I'll get.
The thing is, as we've said, there, and we will go back, to what I said just a moment ago. We will go back to the objective documentation, and if there was a deadline set, the deadline is the deadline. If we find that the deadline is not set, then we will revisit the issue.
As a team player in this county that wants to look out for you guys, there is liability. You're exactly right. I think I will be on the lawsuit as well, but I know that your names will be on there. And so I'm telling you, there are exigent circumstances. There is an employee suffering, and there was a remedy provided, and I am asking that it be followed, regardless of whatever deadline was given. Obviously, it can be removed. And she is asking for that, and she has spoken to me. I have submitted a written request. So you are now aware of it, and I'm just telling you, it is in the best interest of all of us to do something very simple like that. Of course, it can still be sunshine.